I have two principles that guide me here. The first and most important is to commit to facing facts, separating data from demagoguery, and working on an evidence-based approach. Very, very important in this area, and we have to be as disciplined as we can be about doing that. Second, we have to always remind people that the principle of the United States that supersedes and underlies really every other is the principle of equal justice under law. Ours is a system that only functions if we understand that everyone has rights. And equal justice under law is not just something carved over our courthouses. This is fundamental to all of the work we do on laws and all the work we do on public policy. So those two principles in mind led me to get involved in a case that's now pending in the United States Supreme Court. And I want to use that as a way to talk about the framework that I mentioned. I've taken the lead in, and I have 11 other states behind me now, in filing an amicus or friend of the court brief in the case of Arizona v. United States, which is an effort by the federal government, with our support, to overturn an Arizona law known as SB 1070. A famous law, and with good reason. This law provides, among other things, that any state and local law enforcement authority in Arizona is required to detain anyone they, quote, reasonably suspect is in the country without authorization, and that they're not allowed to release them until they can confirm their immigration status with federal authorities. So it essentially orders them to hold people indefinitely until they can get some sort of confirmation. It also makes it a crime for immigrants to be caught without their papers anytime, anywhere. It is a complete rewriting of our national policy of immigration, and it's an attempt to set up essentially a system of deportation on a state-by-state basis, which is totally unacceptable. It will totally disrupt the system as it exists now. Obviously, federal authorities will be forced to respond to these requests, no matter how ridiculous they are, or run the risk of subjecting lots of people, citizens and non-citizens alike, to indefinite detention. This would cripple federal efforts to target the clearly established groups that they're trying to deport, such as criminals and terrorists, and just spend all their time responding to whatever request came from a law enforcement officer in Arizona. So it's horrendous public policy. But it's very important, and I would urge all of you to join me in rejecting both the position that Arizona is taking, but also we need to be very careful about the position the federal government is taking. I'm taking a different position, and the 11 states supporting me are taking a different position than the federal government. The United States essentially has said pretty much all laws relating to immigration are preempted by federal authority. That's to say states can pass very, very few laws in any area relating to immigration. I immediately recognized when I reviewed the case that upholding the federal argument would create problems for state efforts to accommodate and protect the immigrants among us. So, and when my office first entered this effort, there were some other states who didn't like the Arizona law, but were struggling for a way to figure out how to deal with the problem of imposed by the federal argument, which would essentially take all the power away from the states when it comes to dealing with immigration. So what we wanted to do to preserve our rights in this area, and I'm going to talk about a few areas that we work in and that you all work in, where it is critical that state and local government can play a role. We agreed to take the lead on drafting the brief and proceeded to articulate a set of principles that distinguishes and protects appropriate state policies towards immigrants, like consumer protection, labor law, education, healthcare, while making the argument that SB 1070 is unconstitutional. I think this is a very important framework. In fact, I think this is our framework for the next period of time in struggling to protect immigrants and provide for them while struggling to change federal policy regarding admission and deportation. I hope that our framework can be a useful model for all of that work. We argue that states have broad authority to enact and enforce laws affecting all persons within our borders, including documented and undocumented immigrants, particularly when a state law regulates an area of traditional state concern, like education or consumer protection. My contention, now joined by these other states, is that federal immigration law does not preempt that authority. However, we argue, the decision as to who may be allowed into and expelled from the United States, understandably enough, has to be vested in the federal government. Arizona just can't decide. They have their own law on deportation. We can't just decide in New York, well, we're going to start putting people in trucks and taking them to the Canadian border. It has that one area should be protected for the federal government. But that's a much narrower distinction than the other arguments that were presented to the court before we submitted our brief. Obviously, the issue of removal and enforcement activities in aid of removal have uniquely devastating effects. Congress has responded to these concerns by, as I mentioned, prioritizing certain classes of dangerous, undocumented immigrants, or arguably dangerous, undocumented immigrants for removal, and Congress has specifically required federal oversight for non-federal officers who engage in any enforcement activities in aid of removal. That's another provision the Arizona law we contend violates, because they say they can do this on their own without, they reverse it. They say the federal government has to respond to whatever we think they should be doing instead of us having to proceed under federal supervision. So, while we're seeking to strike down SB 1070 and its own Arizona-driven removal policy, we want to say that the only area in which federal authority supersedes state authority has to do with admission and expulsion in the U.S. This is very, very important to everything we're talking about. I'm sure you're talking about here today. Under our narrow preemption argument, laws like the newly proposed DREAM Act or state policies that allow immigrants to collect public benefits are not preempted and cannot be preempted. Our argument enables states like New York to challenge and respond to anti-immigrant federal policies that might attempt to restrict states from providing traditional benefits to immigrants in areas like education, healthcare, or social services. So it's clear to everyone that SB 1070 is an affront to the American tradition of equal justice under law. But I'm hopeful that if our argument prevails, we'll not only prevent other states from adopting pernicious laws like Arizona's, we'll also make it clear that states do have the authority to regulate areas of traditional state concern as they relate to immigrants. So in our state, we do this in many areas. In my office, we do this every day. And I want to preserve the legislature's authority to pass laws to protect people and our office's authority to take action to ensure that everyone's rights are protected.